Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey, just dropping in to say we're now on Patreon. If you want to support the project, head on over to patreon.com/legallistening, where you can unlock some fun bonus content with me, Zach, and some special guests. Thanks so much for all your support. Hey, it's just me. We're about to bring you the dissenting opinion of Justice Lorraine Dubé in the decision of Nova Scotia AG and Walsh. And by we, I mean our special guest, Bennison Smith. If you want to hear Bennison's explanation of the context of the case and hear me and Zach and Bennison chat about the case amongst ourselves, please head on back to the first episode in this series, which is the majority decision. Enjoy!
The following are the dissenting reasons given by Justice Lorraine Dubé. The dissent begins at paragraph 66 of the original decision. Introduction. This case considers the constitutionality of the exclusion of heterosexual unmarried cohabitants from the definition of, quote, spouse, end quote, contained in Section 2, sub G of Nova Scotia's Matrimonial Property Act, or, quote, the MPA. The respondent Walsh challenges this definition, alleging a violation of Section 15, sub 1 of the Canadian Charter of Rights and Freedoms that is not saved by Section 1. For the reasons given by the Court of Appeal, and those that follow, I conclude that the exclusion of heterosexual unmarried cohabitants from this definition is discriminatory, and that this discrimination is not justified by virtue of Section 1 of the Charter. As the respondents Walsh and Bonner have settled their respective property claims, and as the matrimonial property regime has since been amended, I will not consider the appropriate remedy to grant in the present case. Facts. The respondents, Susan Walsh and Wayne Bonner, entered into a relationship in the mid-1980s that culminated in their cohabitation. For reasons unknown to this court, they never married. The story of their long-term relationship is only half told by reference to the record. I would venture to say that beneath the official facts lies a relationship marked by periods of romance, love, happiness, sorrow, despair, and anger. This is characteristic of the many types of relationships formed in this country, and is not unique to Walsh and Bonner. While I confine myself to their story, I readily acknowledge that the following could describe any number of couples living in Canada today. When they began cohabitating, the respondents both lived in Dartmouth, Nova Scotia. At the time, Bonner worked as a community development worker with the Department of Community Services. Walsh also held 2 jobs in Dartmouth as an outreach worker and at a senior citizen center and as a part-time certified nursing assistant. In 1988, Bonner was transferred to River Bourgeois in Richmond County. Walsh, now residing with Bonner, uprooted and moved with him from Dartmouth to continue their lives together. That same year, the respondents became parents after Walsh gave birth to a son, E. Bonner. 2 years later, she gave birth to another son, P. Bonner. On arriving at their new location, Bonner and Walsh purchased a home together as joint owners. Bonner continued to work while Walsh stayed home to raise their 2 children. Income came from Bonner's employment and, for some time, Walsh's unemployment insurance benefits. In 1995, the relationship fell apart. It is accepted that this union lasted for a period of approximately 10 years. After the relationship ended, Bonner sold some cottage property he had acquired as a gift prior to the commencement of cohabitation. The proceeds of sale were used in part to pay off joint debts accumulated by both he and Walsh during their time together. As far as the record is concerned, the story of the relationship ends there. Walsh applied for both child support and spousal support. At the same time, she asked that the definition of quote-unquote spouse in Section 2G of the MPA be declared unconstitutional. Specifically, she argued that the definition, which covers men and women who are married to each other by marriage that is voidable and has not been annulled, or who have gone through a form of marriage with each other, violates Section 15 sub 1 of the Charter. This claim failed at first instance, but was successful on appeal. The appellant, by leave, asks this court to allow the appeal and restore the decision of the Chamber's judge. As my colleague Justice Bastarche notes, the legislature in Nova Scotia has since responded to this litigation by enacting legislation entitling individuals, including heterosexual unmarried cohabitants, to register their domestic partnership with the province. Upon registration, these couples acquire the same presumptive right of equal sharing available to married couples through the MPA. Further, Bonner and Walsh have now settled their respective claims. As such, the case before the court is purely an academic exercise, albeit one of the utmost importance. Issues. The following constitutional questions were stated by the court. 1. Does Section 2 sub G of the Matrimonial Property Act of Nova Scotia discriminate against heterosexual unmarried cohabitants contrary to Section 15 sub 1 of the Charter? 2. If the answer to question 1 is yes, is the discrimination a reasonable limit prescribed by law which can be demonstrably justified in a free and democratic society under Section 1 of the Charter? Legislation and judicial history. I do not feel it is necessary to set out the appropriate legislative provisions, nor to summarize the decisions taken in the Nova Scotia Supreme Court 1999 decision and the Court of Appeal decision. My colleague, Justice Bastarche, has done a commendable job of both, rendering it unnecessary to repeat the exercise here. Analysis. A. Scope of the inquiry. Nova Scotia's matrimonial property regime was altered in 2000 to offer heterosexual unmarried cohabitants the option of opting in to the matrimonial property regime by simply registering their partnership under the Vital Statistics Act. See Law Reform 2000 Act. This new legislation was not in force at the time the respondent Walsh applied for her declaration. I see no need to refer to the new legislation in conducting my analysis. I will therefore confine myself to the wording of the MPA as it stood at the time she made her original application. In doing so, I should observe that several provinces, including Nova Scotia, have either amended their legislation or considered amendments to offer the benefits of the presumption of equal sharing to heterosexual unmarried cohabitants. Pronouncing on the constitutional validity of the legislation currently in force in Nova Scotia might stultify this ongoing process in which several legislatures are now engaged. Legislatures have several options if they should choose to include cohabitants within the scope of their matrimonial property regimes. Possible options include allowing heterosexual unmarried cohabitants to opt into the regime, presuming inclusion unless they opt out by way of contract or through legislative means, ascribing matrimonial status to those who meet particular criteria, or a combination of the above. Legislatures need to know whether a total exclusion of heterosexual unmarried cohabitants from the ambit of their regimes is unconstitutional. It is only they who have the authority to decide who is to be included, subject to the requirements of the Charter. B. Section 15, sub 1. The first question is whether the definition of quote-unquote spouse in the MPA violates Section 15, sub 1 of the Charter. I need look no further than this court's decision in Law and Minister of Employment and Immigration of Canada, 1999, for the appropriate principles to apply to this analysis. While other cases in this court have since dealt with the formula enacted in the Law case, the fundamental concepts associated with Section 15 sub 1 continue to find their greatest expression in the Law test. In the Law case, the court set out a three-stage approach to determine whether Section 15 sub 1 is violated, noting the existence of three broad inquiries. See paragraph 39. One begins by looking to see if the law determines a formal distinction between the claimant and others based on one or more personal characteristics, or whether the law takes into account the claimant's disadvantaged position in society, resulting in substantially differential treatment between the claimant and others based on one or more personal characteristics. The second step entails an examination as to whether this differential treatment is based on a personal characteristic that is enumerated in Section 15 sub 1 or analogous to one such characteristic. Finally, the court considers whether this differential treatment substantively discriminates. This final inquiry draws inspiration from the purpose of Section 15 sub 1 as a remedial tool against prejudice, stereotyping, and historical disadvantage. I will specifically deal with each of these steps later in my reasons. It suffices to note that the third step involves a full and complete review of several contextual factors. In conducting this three-stage analysis, it is appropriate to remember that fundamental to the equality rights guarantee is its broad remedial purpose, namely, the recognition of the innate dignity of each and every human being in our society. This fundamental purpose is violated whenever a sufficient distinction is drawn between individuals or groups on an enumerated or analogous ground in such a way as to reflect the stereotypical application of presumed group or personal characteristics, or so as to create the effect of perpetuating or promoting the view that the claimant is less capable or less worthy of recognition or value as a human being. See the law case Supra at paragraph 51. Justice Iacobucci in the law case sets out at paragraph 53 this court's understanding of what is meant by human dignity. Quote, "There can be different conceptions of what human dignity means. For the purpose of analysis under section 15 sub 1 of the Charter, however, the jurisprudence of this court reflects a specific, albeit non-exhaustive, definition. As noted by Chief Justice Lemur in Rodriguez and the Attorney General of British Columbia, 1993, at page 554, the equality guarantee in section 15 sub 1 is concerned with the realization of personal autonomy and self-determination. Human dignity means that an individual or group feels self-respect and self-worth. It is concerned with physical and physiological integrity and empowerment. Human dignity is harmed by unfair treatment premised upon personal traits or circumstances which do not relate to individual needs, capacities, or merits. It is enhanced by laws which are sensitive to the needs, capacities, and merits of different individuals, taking into account the context underlying their differences. Human dignity is harmed when individuals and groups are marginalized, ignored, or devalued, and is enhanced when laws recognize the full place of all individuals and groups within Canadian society. Human dignity, within the meaning of the equality guarantee, does not relate to the status or position of an individual in society per se, but rather concerns the manner in which a person legitimately feels when confronted with a particular law. Does the law treat him or her unfairly, taking into account all of the circumstances regarding the individuals affected and excluded by the law?" End quote. Dignity is by its very nature a loaded and value-ridden concept comprising fundamental assumptions about what it means to be a human being in society. It is an essential aspect of humanity, the absence of which is felt by all members of society. To this extent, the promotion of human dignity and the prevention of actions that compromise its full exercise is a matter with which every member of society is concerned. It is for that reason that the promotion of human dignity finds expression in one of our most important legal documents, namely the Charter. The importance of the remedial aspect of section 15 sub 1 must also be borne in mind when dealing with each stage of the law analysis, but most especially the third stage. At the third stage, the court is concerned with whether a distinction that is being drawn constitutes discrimination in the substantive sense that the distinction fails to serve the aforesaid purposes. As such, all courts must bear in mind that the guidelines in the law case are merely guidelines. They do not represent a strict test. See the law case Supra at paragraph 88 and M and H 1999 at paragraph 46. Instead, this court must approach this case with regard to the full context in which this challenge is brought. A mechanical or overly formal approach may serve to undermine the purposes of section 15 sub 1 described above, whereas a broad, liberal, contextual approach enables the court to fully appreciate the claim and the alleged violation of human dignity. It should also be borne in mind that differential treatment is, by nature, a comparative concept. The court is required to identify differential treatment by observing the way the legislation treats two comparator groups. I do not propose to speak any further on this matter. It is clear in this case that the groups under comparison are heterosexual married cohabitants and heterosexual unmarried cohabitants. The MPA confers its benefits only on the former. The latter is the group to which the respondent Walsh belongs. The court is merely concerned with whether drawing a distinction between heterosexual cohabitants on the basis of their marital status constitutes a violation of Section 15, Sub 1 of the Charter. I conclude these preliminary remarks by observing that this court is required, when conducting the above analysis, to review the claim from the perspective of a reasonable, dispassionate person, fully apprised of the circumstances and possessing similar attributes to those of the claimant. See the law case, supra, at paragraph 60, referring to my comments in Egan and Canada, 1995, at paragraph 56. This subjective-objective appraisal is necessary in order to recognize the reality of the claimant's situation while situating that claimant in the proper comparator group. The fact that the respondent Walsh has gone to the trouble of initiating this litigation and carrying it this far suggests that, subjectively, she regards the definition of quote-unquote spouse as constituting a violation of her inherent human dignity. The question, however, is whether a person reflecting objectively on the claimant's situation would regard the exclusion of all heterosexual, unmarried cohabitants as being a violation of the claimant's dignity. The objective element of the test also enables the court to conduct the full contextual appraisal I noted earlier, evaluating in particular the individual or group's, quote, traits, history, and circumstances, end quote. See the law case at paragraph 60. No analysis would be complete without this broad evaluation. Step 1. Differential treatment. As the appellant concedes, the MPA draws a distinction between married persons and heterosexual unmarried cohabitants. Only the former are included within the definition of quote-unquote spouse. The latter are wholly excluded. This results in one regime for married persons, the matrimonial property regime, and another for unmarried ones through the use of doctrines such as unjust enrichment. A formal distinction is thus drawn based on a personal characteristic, namely marital status. The distinction itself results in substantially differential treatment between the two groups. I prefer to deal with that issue in Step 3, where I enter into the discussion of the sufficiency of common law remedies as an aspect of human dignity. The appellant argued in the Court of Appeal that the respondent Walsh was not denied equal benefit under the law. In essence, no distinction was being drawn. The Attorney General based its argument on the fact that married couples are themselves not, quote-unquote, entitled to 50% of the matrimonial assets upon dissolution of the marriage. They are merely given a presumption of entitlement. The Court of Appeal correctly rejected this argument. What we are dealing with here is a clear denial of a benefit to all heterosexual unmarried cohabitants, namely the benefit of a strong presumption favoring equal sharing. As Justice Corey says in M and H supra at paragraph 66, referring to Egan supra at paragraphs 158 to 159, and Vrend and Alberta 1998 at paragraph 87, quote, "The type of benefit salient to the Section 15 Sub 1 analysis cannot encompass only the conferral of an economic benefit. It must also include access to a process that could confer an economic or other benefit." End quote. Absent the presumption, people are left with the burden of proving contribution to the acquisition and maintenance of assets, a burden not easily discharged without incurring higher litigation costs than one would incur with a presumption of equal contribution and benefit. It must also be observed that the MPA confers other benefits on spouses not available in other legislation or at common law. For example, Sections 6 sub 1 and 11 sub 1a provide each spouse with a right to apply to court for an order of exclusive possession of the matrimonial home. The quote-unquote matrimonial home is defined in Section 3 sub 1 as a home occupied by a person and that person's quote spouse, and in which at least one of the two persons has a property interest. Given the definition of quote-unquote spouse in the MPA, this benefit is unavailable under the MPA to heterosexual unmarried cohabitants. Overall, these people are denied both access to a process that could confer a benefit the presumption, as well as direct benefits solely by virtue of their unmarried status. Again, I will deal with this in greater depth at the third stage of the law analysis. It suffices for me to indicate at this point that the remedies available at common law are sufficiently different from those under the MPA that substantially differential treatment has been made out here. Step 2. Enumerated or analogous grounds. While marital status does not find expression in section 15 sub 1 of the Charter, this distinction is based on an analogous ground to those listed therein, a matter which the appellant also conceded. Marital status was specifically recognized by this court in Myron and Trudel, 1995, to be an analogous ground under section 15 sub 1 of the Charter, see paragraph 156. In light of this court's comments in Corbière and the Minister of Indian and Northern Affairs of Canada, 1999, at paragraph 8, and in Lavoie and Canada, 2002, at paragraph 41, it is now the law that once a ground is determined to be analogous, it is permanently regarded as analogous in all subsequent cases. As a result, the finding in Myron that marital status constitutes an analogous ground of discrimination binds this court to make the same finding in this case. Step 3. Substantive discrimination. Given the appellant's concessions with respect to the first two steps, it has already been established that there exists formal discrimination in this case. The real question raised by this appeal is whether the distinction drawn in the MPA violates the purpose of section 15 sub 1 by drawing a distinction which has the effect of diminishing the claimant's dignity. Does this distinction reflect the stereotypical application of presumed group or personal characteristics so as to create the effect of perpetuating or promoting the view that the claimant is less capable or less worthy of recognition or value as a human being? In the law case, Justice Iacobucci noted a number of contextual factors one should take into account at this stage of the analysis. I will review each of these factors, first following which I shall enter into a review of other matters that ought to inform the analysis at this stage. I reiterate that this broader review is necessitated by the need to ensure that this claim be situated in its full legal, social, and historical context, so as to ensure that the broad remedial purpose of section 15 sub 1 is served. Simply looking at law's four contextual factors is not sufficient to accomplish this task in the present case. In Andrews and the Law Society of British Columbia, 1989, Justice McIntyre observed the following at pages 174 to 175. Quote, "Distinctions based on personal characteristics attributed to an individual solely on the basis of association with a group will rarely escape the charge of discrimination, while those based on an individual's merits and capacities will rarely be so classed." End quote. These comments were quoted with approval most recently in the law case at paragraph 26. The reason such distinctions rarely escape the charge of discrimination is that groups sharing similar characteristics seldom have needs, desires, and expectations that are so different from each other so as to justify treating them differently as a whole based on their membership in that group. Differential treatment is far easier to justify where the legislation provides benefits based on actual needs, merit, and capacity. Are heterosexual unmarried cohabitants so different from married ones as a whole so as to justify denying all members of the group access to the benefits of the MPA? This question can only be answered by reference to the four factors enumerated in the law case, as well as the purpose of the MPA: the choice of marriage and non-marital cohabitation, the present sociological reality of multiple family structures, the current recognition cohabitants already enjoy at law, and the present inadequacies with those remedies currently available to separating cohabitants. A. Pre-existing disadvantage. The existence of pre-existing disadvantage, vulnerability, stereotyping, or prejudice is an important indicator that the claimant forms part of a group historically regarded as deserving less concern, respect, and consideration. See the law case at paragraph 63. This vulnerability is exacerbated whenever the legislative provisions under scrutiny continue to draw a distinction on a ground touching on this pre-existing disadvantage. See M and H at paragraph 68. With respect to the present case, this court has recognized that, unmarried heterosexual cohabitants have historically suffered a degree of vulnerability and disadvantage not experienced by married cohabitants. In Myron, Justice McLaughlin, as she was then, wrote the following at paragraph 152. Quote, persons involved in an unmarried relationship constitute a historically disadvantaged group. There is ample evidence that unmarried partners have often suffered social disadvantage and prejudice. Historically, in our society, the unmarried partner has been regarded as less worthy than the married partner. The disadvantages inflicted on the unmarried partner have ranged from social ostracism through denial of status and benefits. In recent years, the disadvantage experienced by persons living in illegitimate relationships has greatly diminished. Those living together out of wedlock no longer are made to carry the scarlet letter. Nevertheless, the historical disadvantage associated with this group cannot be denied. End quote. In the 1960s, marriage was the only legally recognized family form. As W. Holland points out, the few acknowledgments of the existence of unmarried cohabitants and their families tended to be scathing and insulting. In 1936, C. Brinton, speaking on the topic of marriage and children, spelled out the following prevailing conception of marriage and its notional legitimacy. Quote, bastardy and marriage in this world are quite supplementary. You cannot have one without the other. In another world, you may indeed separate the two institutions and eliminate one of them, either by having marriage so perfect in various senses that no one will ever commit fornication or adultery, or by having fornication so perfect that no one will ever commit marriage. But these are definitely other worlds. End quote. Such notions creep into the case law as well. In Grammons and Eakins, 1950, the defendant resisted an order of possession by a landlord of property leased to a woman with whom the defendant had a close relationship lasting some 20 years. The relevant legislation required proof that the defendant was a member of the tenant's quote-unquote family in order to make out any defense. In rejecting the defense, Justice Asquith made the following comments at pages 141 to 142. Quote, if the relationship involves sexual relations, it seems to me anomalous that a person can acquire a status of irremovability by having lived in sin, even if the liaison has been not a mere casual encounter, but one protracted in time and conclusive in character. To say of two people masquerading as these two were, as husband and wife, that they were members of the same family, seems to me an abuse of the English language. End quote. Comments like these would have been perfectly acceptable to a society that regarded children born out of wedlock as bastards, for instance. In a society that associated unmarried cohabitation with sin or immorality, the recognition of these relationships as one deserving respect and consideration would have been seen as absurd. In many respects, the pre-existing disadvantage faced by heterosexual unmarried cohabitants was mainly the result of omission. People living together outside of marriage were generally ignored. Statistics showing the number of heterosexual unmarried cohabitants living in Canada were not available until 1981. The 1991 census contained the first questions ever specifically related to common law status. These facts are perhaps not surprising when one considers that the first law reform reports dealing with attempts at providing for modern matrimonial property regimes in the late 1970s and early 1980s never dealt with heterosexual unmarried cohabitants. The one exception was New Brunswick, where a discussion paper appeared in 1978 recommending the extension of some matrimonial property rights to this group. None of the other law reform commissions appear to have turned their mind to the issue at all before the enactment of legislation in their respective provinces. It is therefore clear that notwithstanding recent strides made towards recognition, the extent of which I shall discuss further below, heterosexual, unmarried cohabitants have historically suffered and continue to suffer to some extent from the existence of disadvantages associated with their non-marital status. The failure to recognize this in the MPA therefore contributes greatly to a loss of dignity for members of this group. B. Relationships between grounds and the claimant's characteristics or circumstances. Under this heading, the court is asked to consider the extent to which the legislation in question takes into account the actual needs, capacity, or circumstances of the claimant. See the law case at paragraphs 69 to 70. In order to avoid an overly mechanical application of the law factors, I would prefer to deal with the needs of the claimant and all heterosexual unmarried cohabitants later. In order to properly understand this matter, one must inquire into both of their needs and the extent to which the law already accounts for them. It suffices to point out now that the disintegration of a long-term relationship of 10 years, such as the one involved in the present case, is then one that creates a real need for a redistribution of wealth, both by means of support and division of assets. In Peter and Biblo, 1993, Justice Corey observed at page 1014 that the 12-year unmarried relationship involved in that case was by no means insignificant. According to him, such a relationship ought to give rise to mutual rights and obligations. By failing to accord the claimant a presumption of equal contribution and equal sharing, the MPA denies her access to the most expedient means of resolving the very difficult matters associated with the dissolution of a long-term relationship at a time where patience and emotional stability are at a premium. Instead, the MPA forces the claimant to make out her claims in equity, with all the attendant expense and problems of proof associated with such a claim. This contributes to a violation of the dignity of both the claimant and all heterosexual unmarried cohabitants. C. Ameliorative purpose or effects. This factor involves a consideration of the MPA's ameliorative purposes or effects upon a group or person more disadvantaged than the claimant or heterosexual unmarried cohabitants in general. There does not appear to be such an ameliorative aspect to the MPA. Instead, the present case is more akin to the situation in M and H, where Justice Corey observed at paragraph 71 that, under inclusive, ameliorative legislation, which excludes from its scope the members of a historically disadvantaged group, will rarely escape the charge of discrimination. The present case does not involve an attempt by the legislature to allocate scarce resources among members of various disadvantaged groups. As the Court of Appeal commented at paragraph 58, including heterosexual unmarried cohabitants within the scope of the MPA will involve no cost consequences to both the government and married cohabitants. A reasonable individual possessing the claimant's attributes would infer from this that the exclusion of heterosexual unmarried cohabitants serves no ameliorative purpose and has no such beneficial effect. Instead, the absence of such attributes merely confirms the perception that the MPA constitutes an attack upon the dignity of the claimant and all heterosexual unmarried cohabitants. D. Nature of the interest affected. The final law factor is clearly enunciated in M and H at paragraph 72 as follows, quote, "The discriminatory caliber of differential treatment cannot be fully appreciated without considering whether the distinction in question restricts access to a fundamental social institution, or affects a basic aspect of full membership in Canadian society, or constitutes a complete non-recognition of a particular group." End quote. Justice Corey observed that the interest protected by the legislation in that case, namely, the right to spousal support, was fundamental in nature. Spousal support is an essential means by which individuals meet their basic financial needs following the dissolution of a relationship characterized by intimacy and economic interdependence. The same holds true for matrimonial property. In Moog and Moog, 1992, I wrote at page 849 that the Divorce Act requires a, quote, "fair and equitable distribution of resources to alleviate the economic consequences of marriage or marriage breakdown for both spouses, regardless of gender," end quote. I also observed earlier in those reasons that this equitable distribution can be achieved in many ways, by spousal support, child support, the division of property and assets, or a combination of these. Those comments apply with equal vigor to proceedings taken under various provincial statutes. What these remarks demonstrate is that both spousal support and asset division serve the same purpose of alleviating the economic burden imposed by the dissolution of a long-standing relationship of intimacy and mutual economic dependence. Functionally, there is indeed no real dividing line between support obligations and those imposed by matrimonial property regimes. See the Holland case at page 153. It follows from this discussion that the prima facie right to an equal division of property and assets is of fundamental importance. Since the right to spousal support has already been recognized as fundamental, any other result would prove to be inconsistent. The fact that the claimant and all heterosexual unmarried cohabitants are being denied such a fundamental right, as opposed to a trivial one, adds important weight to the argument that the MPA discriminates. E. Recognizing contributions to non-marital relationships, the purpose of the MPA. At paragraph 35, my colleague, Justice Bastache, stresses the importance of distinguishing between the intentions of married persons and heterosexual unmarried cohabitants upon entering into their respective relationships. Quote, "The most important aspect of this question is not whether the situation in which Walsh and Bonner found themselves at the time of trial was similar to that of married persons, but whether persons entering into a conjugal relationship without marrying are, in fact, entering into a relationship on the same terms as persons who marry." End quote. In effect, the appellant's position was that it was constitutionally justified in treating two different relationships differently, most notably by giving effect to the intentions of those entering into the two types of conjugal relationships involved. The Court of Appeal instead chose to focus on whether the complete non-recognition of the contributions made by heterosexual unmarried cohabitants to their relationship constituted discrimination. Given the purpose of the MPA, I believe that the Court of Appeal's focus on this crucial point was sound. In this section, I will deal with the purpose of the MPA and the non-recognition of contributions made by non-married persons. In doing so, I am mindful of Justice McLaughlin's comments in Myron at paragraph 134 that the goal under section 15 sub 1 is to examine the actual impact of the distinction on the members of the targeted group, in this case, heterosexual unmarried cohabitants. In section F, I will focus on the notion of intention in the formation of relationships. Purpose of the MPA: recognizing a need. Prior to the enactment of the predecessor to the MPA, and to all matrimonial property statutes in the various provinces, the situation for married spouses was a grim one in Canada. At the time, common law provinces administered the regime of property separately. The concept of separate property was simply that each party to a marriage retained title to their respective property, both during the marriage and after its dissolution. Separate property was a revolutionary concept developed in the late 19th century as a means of ending the oppression caused by common law matrimonial property laws then in existence. Those earlier laws subordinated any interest the wife would normally have to property to that of her husband, with the husband becoming the sole owner of any property belonging to the wife. Under such a regime, the end of a marriage meant that each partner walked away with all of the property in which they had title, or in which they were regarded as the legal owner. The problems this created were real, but far less acknowledged in a society where the incidence of divorce was somewhat low. After the Divorce Act was enacted in 1968, divorce became more common as a social phenomenon. With divorce came the economic problems associated with it, and resulting court challenges to redress these situations. At first, claims to a share in property belonging to the other spouse fell on deaf ears. In the notorious case of Murdoch and Murdoch, 1973, Justice Laskin, as he then was, dissenting, this court refused to allow a wife of 25 years to obtain any interest in the property, the title to which was held in her husband's name. All claims in equity and partnership failed. Despite one successful attempt by this court a few years later to redress this shameful situation in Rathwell and Rathwell, 1978, the result in Murdoch served as the ultimate catalyst for legislative reform of existing separate property regimes. The roots of those reforms can be traced back to a desire to ensure the contributions of each spouse to the marital relationship be recognized. In 1970, the Royal Commission on the Status of Women in Canada issued a report dealing with a considerable number of issues relevant to women at the time. In this report, a significant part dealt with the issue of matrimonial property law. The following recommendation was drafted. Quote, "We recommend that those provinces and territories which have not already done so amend their law in order to recognize the concept of equal partnership in marriage, so that the contribution of each spouse to the marriage partnership may be acknowledged, and that, upon the dissolution of the marriage, each will have a right to an equal share in the assets accumulated during marriage." End quote. It is clear from this passage that the principal consideration animating the attempt to reform the law of property in this area was the desire to recognize and acknowledge the contribution of each spouse to the marriage. Implicit in this statement is the understanding that existing property laws did not adequately serve those purposes. In 1975, Canada's Law Reform Commission echoed these sentiments in a working paper. It went even further by stating that the existing regime of separate property constituted an affront to the dignity and worth of the spouse, whose contributions are not recognized. Marriage almost invariably creates a differentiation in functions between the partners. Application to a family unit of the ordinary property laws that exist in a separate property jurisdiction fails to recognize this fact. The result is not only economic inequality, but also a denial of the legal dignity and worth of the spouse who raises the children and works in the home, rather than taking outside employment. See Law Reform Commission of Canada Working Paper, Studies on Property, Family Law, 1975. In response to these fervent criticisms of existing property laws and to injustices caused by their application in cases such as Murdoch, Canada's provinces and territories enacted legislation recognizing marriage as a socio-economic partnership. This recognition took the form of a presumption of equal entitlement to a specific set of assets, which presumption would apply on the breakdown of the marital relationship. Nova Scotia enacted its first matrimonial property legislation in 1980, the predecessor to the MPA. See the Matrimonial Property Act of Nova Scotia, 1980. The preamble to the MPA and its predecessor contains the following pronouncements, quote, "Whereas it is desirable to encourage and strengthen the role of the family in society, and whereas for that purpose it is necessary to recognize the contribution made to a marriage by each spouse, and whereas, in support of such recognition, it is necessary to provide in law for the orderly and equitable settlement of the affairs of the spouses upon the termination of a marriage relationship, and whereas it is desirable to recognize that childcare, household management, and financial support are the joint responsibilities of the spouses, and that there is a joint contribution by the spouses, financial and otherwise, that entitles each spouse equally to the matrimonial assets." End quote. In stark and simple terms, the preamble depicts a desire to recognize the contribution made by each spouse to the relationship and to the family, such contribution taking on the form of childcare, household management, and financial support. These three facets are acknowledged to be the joint responsibility of each spouse. In recognition of this joint responsibility and its discharge, the legislation presumes an equal entitlement to the matrimonial assets. The central theme, clearly, is the recognition of all contributions made by both spouses to the care and support of the family, it being stated that the family is central to society. In Clark and Clark, 1990, Justice Wilson wrote that the MPA's predecessor is, quote, "remedial in nature," end quote. She further states that the statute was designed to, quote, "alleviate the inequities of the past when the contribution made by women to the economic survival and growth of the family was not recognized." End quote. I pause here to observe that the MPA is designed to be gender neutral. It recognizes the contribution made by both the male and female spouse. Justice Wilson's comments merely reflect the reality that the pre-MPA property regime had a greater prejudicial effect on women than on men. Finally, Justice Wilson holds that this purpose must be borne in mind, and the MPA must be given, quote, "a broad and liberal construction which will give effect to that purpose," end quote. I agree with these comments, given my review of the historical context giving rise to the enactment of the first matrimonial property statutes. The statutes are remedial in nature. In effect, a remedial statute is one that recognizes a need and remedies it. Similar comments have been expressed by this court on other occasions involving related pieces of legislation. As I noted earlier, I wrote in Moog at page 849 that the Divorce Act is designed to alleviate the economic burden created by the dissolution of the marital relationship. In M and H, at paragraph 93, Justice Iacobucci identified several purposes served by the spousal support provisions in Ontario's Family Law Act. These included lessening the burden on the public purse that would otherwise result without spousal support, and providing for a fair and equitable resolution to disputes arising upon the dissolution of the relationship. The preamble to Ontario's Family Law Act is written in much the same way as the preamble to the MPA. Both are designed to recognize a need, namely the need for an equitable resolution to the dissolution of the relationship and the need to ensure that the public does not needlessly pay the costs associated with this breakdown. Both recognize this need through different means. In the case of the MPA, this is through a presumption of equal property sharing, while in Ontario, the statute covers spousal support, child support, and the division of property. The consistent message from this court is that family legislation of this type is remedial in that it recognizes a need and provides for its relief. This remedial interpretation is further supported by reference to the fact that the presumption of equal sharing only arises when the relationship comes to an end. Quote, "The right to an equal division arises only at the end of a marriage. Before then, each spouse retains title to whatever property is in their name, and they may freely dispose of it without the consent of the other spouse. Until the relationship is ended, there is no need for wealth redistribution of the kind contemplated by the MPA. The need the legislation addresses is one that only arises when the relationship is terminated. This need is further illustrated by the desire to avoid diverting funds from the public purse in order to support separated individuals. It is no secret that divorce increases the likelihood that one of the divorced spouses will fall below the poverty line. This problem is no different from heterosexual unmarried cohabitants who experience the end of their relationship. In a report released in 1992, one author noted that, quote, "The end of a marriage, or emphasis, common law relationship, end emphasis, increased the likelihood of poverty substantially. For those who were married and had children, the risk of poverty rose from 3.1% to 37.6% after divorce or separation. In 1982 to 1986, the family income of women, adjusted for changes in family size, dropped by an average of about 30% in the year after their marriage ended," end quote, emphasis added. The goal of matrimonial property regimes, and indeed the goal of family law generally, is a redistribution of economic resources on the breakdown of the family. While the relationship is a going concern, this redistribution is presumed to occur automatically. Family law only steps in on dissolution to distribute resources and alleviate economic burdens. The preamble, this court's previous statements concerned the goals of matrimonial property and similar legislation. The prevention of poverty and the use of public funds all point to one purpose for the MPA, that of recognizing the problems that erupt at the end of the relationship and redistributing wealth to ensure that these problems are resolved. Infused in this interpretation is the notion that both parties have contributed to the relationship and that, in recognition of this contribution, wealth will be presumed to be distributed to each party equally. The needs of heterosexual, unmarried cohabitants. This brings me to the central theme of this factor. I hold that heterosexual, unmarried cohabitants experience similar needs as their married counterparts when the relationship comes to an end. In this sense, the relationships are functionally equivalent. Since the purpose of the MPA is to recognize this need and to alleviate it, limiting the recognition to married cohabitants further implies that the needs of heterosexual, unmarried cohabitants are not worthy of the same recognition solely because the people in need have not yet married. Further, the MPA equal presumption is based on the recognition of the contribution made by both spouses to the family. Functionally, spouses contribute to various types of families. Failing to recognize the contribution made by heterosexual, unmarried cohabitants is a failure to accord them the respect they deserve. This failure diminishes their status in their own eyes and in those of society as a whole by suggesting that they are less worthy of respect and consideration. Their dignity is thereby assaulted. They are victims of discrimination. In the past 20 years, Canada has seen a remarkable increase in the number of people living together in unmarried relationships. The number of families involving two unmarried parents has also greatly increased. Canadian society is therefore at a stage where it is no longer realistic to talk about familial bonds, the socialization of children, and all other aspects of family in a quote, married couples only, end quote, vacuum. The reality of modern society dictates a richer understanding of the various forms of familial relations in this country, and the shedding of the idea that family life is reserved to one particular conception of what is deemed to be an acceptable family model. Support for this change in family structures can be gleaned from a number of surveys and related materials. In 1997, StatsCan published its report on the data gathered in the 1996 census related to common law unions. See Statistics Canada 1996 census, published in 1997. Parts of this report are reproduced by the Court of Appeal. In 1996, 920,635 common law couple families were counted, up 28% from 1991. This means that 1 couple in 7 in Canada was living quote-unquote common law. Comparatively, only 1 couple in 16 was in a common law union in 1981. The census defines common law partners as, quote, 2 persons of opposite sex who are not legally married to each other but live together as a husband and wife in the same dwelling, end quote. In Nova Scotia, approximately 10% of all families counted in 1996 were common law families. I also note that the 1996 census counted 1,827,284 persons living in common law unions. At the same time, 13,509,895 people were living in couples generally. As a result, 13.53% of people living in couples lived in a common law union. In Nova Scotia, there were 430,095 people living in couples in 1996. 47,925 of these people, or 11.14%, lived in common law unions. Interestingly, among all Canadians, only 713,210 people lived in a common law union in 1981. More interestingly, nearly 40% of all people aged 15 to 29 living as a couple lived in a common law union in 1996. The number was only 30% in 1991. The growth in the number of people living in non-marital relationships does not appear to be diminishing. If anything, these statistics signals an increased trend away from marriage toward unmarried cohabitation relationships. For example, between 1990 and 1994, the number of first union marriages formed in Canada, Quebec excluded, equaled the number of first union common law unions formed. During that same period, the ratio was 4-1 in favor of new common law unions in Quebec. Dumas and Bélanger postulate that if the same growth rate is maintained for marriage and non-marital unions, the number of married couples will equal the number of common law couples by Canada by 2022. The census report noted above further details the growing change in Canadian society by reference to the increasing number of children born to heterosexual unmarried couples. In 1996, 735,565 children were living in, quote, common law couple families, end quote. This represented a significant increase of 52% over the same number of such children in 1991. Many of these trends are further reflected in the latest statistical data. In 2001, nearly 14% of all Canadian families were classified as, quote, common law families, end quote, up from 13.53% mark set 5 years earlier. In Nova Scotia, the percentage of families labeled as, quote, common law families, end quote, went up from 9.5% to 11.4%. What these statistics indicate in a nutshell is that the phenomenon of non-marital cohabitation is by no means an isolated one. Increasingly, Canadians have come to live in non-marital relationships. Further, they are choosing more and more to raise their children within these relationships. Based on these and other statistics, several authors have advocated for the redefinition of what is meant by the term family. Wu's conclusion at pages 88 to 89 is simple, quote, the rise in non-marital fertility and the decline in teen fertility are consistent with my unconfirmed view that much of the increase in non-marital fertility in recent decades may have been largely a consequence of the increase in non-marital cohabitation, and that more and more children have been born into cohabitating families over time. If I am correct, then cohabitation is slowly but surely becoming a substitute for legal marriage as a social institution where children are born, raised, and socialized to become members of society. End quote. A similar conclusion is reached by Dumas and Bélanger. Quote, the common law union is no longer a trial period of living together, but increasingly a substitute for marriage. End quote. The increased incidence of heterosexual unmarried cohabitation as a means by which children are raised and socialized, and as a form of economic, emotional, and social interdependence dictates some form of recognition of the functional equality displayed by both heterosexual married and unmarried cohabitants. The family is no longer an institution reserved for married persons. In essence, the family is a matrix of relationships through which values are transmitted. Members are socialized and children are raised. Disregarding the matrix because two of its members are unmarried fails to take into account the social reality the same incidents of interdependence are faced by both married and unmarried living together in these relationships. I am not the first to say this. In Petkus and Becker, 1980, the court was faced with an attempt by two heterosexual unmarried cohabitants to extend the equitable principles developed in Rathwell for married couples to those not legally married. Justice Dixon, as he then was, saw no reason not to grant this request. Quote, "I see no basis for any distinction in dividing property and assets between marital relationships and those more informal relationships which subsist for a lengthy period." End quote. This was the first step in the court's attempt to identify heterosexual unmarried cohabitation as functionally equivalent to married cohabitation. The trend continued in a few later cases dealing with family law generally. In Moog, at pages 848 to 849, I defined the family in terms of the values associated with it and the purpose it serves. Families provide for the emotional and social economic well-being of its members. The family serves as a support system for its members. It is the place where human beings find their utmost intimate human contact. The family was also described as a forum where the values are transmitted and social skills are fostered and developed. I further observed that the family is a structure that often entails the making of sacrifices by its members. Picking up on this theme in the Attorney General of Canada and Mossop, 1993, I wrote the following at page 632, quote, "What is important is that children be nurtured. The critical factor is not the family form, nor the presence of mixed-sex role models, but the provision of a loving and nurturing environment. From this perspective, the ideal family is one which meets the needs of its members and best attempts to realize the values that lie at the base of the family. As Jane Larson says, it is the social utility of families that we all recognize, not one proper form that, quote, the family, end quote, must assume. It is the responsibility and community that the family creates that is its most important social function and its social value, end quote. My reasons in Mossop indicate that the family, as a concept, is not limited to those involving two heterosexual parents who are married. The family is a functional concept based on a structure that meets the needs of its members and nurtures them in a manner described earlier. Defining the family with reference to one form ignores the reality that the functions of the family are served by all types of families in modern society. This is something that has been recognized in this court. It is for this reason that I disagree with my colleague Justice Gonchier's attempt to equate marriage with family. While Justice Gonchier is right in his attempt to signal the importance of marriage to society and to acknowledge the distinctions that inhere in families where the primary caregivers are married and those where they are not, it is my view that referring to these distinctions does not, in itself, end the analysis. The presence of such differences cannot be used to deny benefits where the provision of these benefits is not tied to those differences. In fact, it is quite legitimate to recognize differences in family forms and to be pro-family and pro-marriage without having to resort to denying benefits to other legitimate family forms. As I wrote in Mossop at pages 633 to 634, quote, "Given the range of human preferences and possibilities, it is not unreasonable to conclude that families may take many forms. It is important to recognize that there are differences which separate, as well as commonalities which bind. The differences should not be ignored, but neither should they be used to delegitimize those families that are thought to be different. As Audre Lorde puts it in, quote, Age, Race, Class, and Sex, Women Redefining Difference in Sister Outsider, published in 1984 at page 122, we must recognize differences among people who are equals, neither inferior nor superior, and devise ways to use each other's differences to enrich our visions and our joint struggles. In light of all of this, it is interesting to note that, in some ways, the debate about family presents society with a false choice. It is possible to be pro-family without rejecting less traditional family forms. It is not anti-family to support protection for non-traditional families. The traditional family is not the only family form, and non-traditional family forms may equally advance true family values." End quote. By denying functionally equal relationship benefits based on a status wholly unrelated to their needs, the MPA ends up drawing an inappropriate distinction. N. Desrosiers puts it this way, quote, "In a democratic society, hierarchies between forms of relationships based on status are not appropriate. The best that a state can do is create conditions for equal and non-exploitative relationships to develop." End quote. The equivalency of functions described above gives rise to identical needs upon the breakdown of family relationship. As both marital and non-marital cohabitation can be characterized by emotional, social, and economic interdependence, it follows that the termination of these relationships generates similar problems. This is implicit from Justice Dixon's decision in Petkus, where the court finds no underlying reason to treat heterosexual unmarried cohabitants differently as regards the division of assets through equity. A more express statement of this court's acceptance of the fundamental similarities associated with the breakdown of both types of relationships is to be found in the judgment of Justice Laforêt in Egan at paragraph 23, quote, "Many of the underlying concerns that justify Parliament's support and protection of legal marriage extend to heterosexual couples who are not legally married. Many of these couples live together indefinitely, bring forth children, and care for them in response to familial instincts rooted in the human psyche. These couples have need for support just as legally married couples do in performing this critical task, which is of benefit to all society. Language has long captured the essence of this relationship by the expression common law marriage." End quote. Academic commentators have long since taken note of the fact that the difficulties associated with the breakdown of a traditional marriage manifest themselves in other less traditional relationships. K. L. Kuffner writes, quote, "Common law couples often share many of the same characteristics as married couples: shared accommodations, pooling resources, emotional and financial interdependence, and the raising of children. Some cohabitants have become financially dependent on their spouse, similar to some married spouses. Consequently, cohabitants often suffer similar hardships upon breakdown of such relationships." End quote. Today, there is very little difference between marriage and cohabitation. Marriage encompasses a range of relationships, some characterized by various forms of dependency, while others involve spouses who are quite independent, financially and otherwise. Marriage may or may not involve procreation. Cohabitation relationships are found along a similar spectrum. There is no reason to differentiate between the two based on the notion that cohabitation is different from traditional marriage. When we compare cohabitation and modern-day marriage, there are few distinctions." End quote. The facts have not been lost on law reformers as well. In Nova Scotia, the Law Reform Commission released its report in 1997, dealing with the proposed changes to the MPA that would allow individuals, including heterosexual unmarried cohabitants, to claim similar benefits to their married counterparts. The Commission's conclusions regarding the nature of unmarried relationships are aptly set out at page 21 of their final report. Quote, "The Commission has reached the view that most cohabitation relationships are functionally similar to marital relationships and deserve to be treated similarly by the law. Human beings seek out long-term relationships for a variety of reasons, including companionship, love, emotional support, sexual intimacy, procreation, economic need, and social expectation. Such relationships, especially but not exclusively where there are children, often generate patterns of economic dependency. These patterns, which may not be apparent during the relationship, are exposed to its termination. The reason for the law to impose property division in marriage and cohabitation relationships is to respond to the economic interdependence which arises in such relationships, and to ensure the dependent partner is not punished for the role which he or she has been playing during the relationship." End quote. Similar thoughts are echoed in the Ontario Law Reform Commission report on the rights and responsibilities of cohabitants under the Family Law Act. At page 27 of the report, the Commission observes that society values the performance of the functions associated with marital and non-marital relationships. Having linked the two together based on the functions each performs and the recognition of the value of those functions, the Commission concludes that the law ought to apply equally to both types of relationships. One complaint that could arise from such extension of benefits accorded married cohabitants under the MPA to heterosexual unmarried ones involves the fact that the latter are, on average, relationships of shorter duration than marriages. It is argued that, as a result, a greater percentage of unmarried cohabitants do not leave their relationship in a similar state of mutual interdependence as does the average married cohabitant on the dissolution of marriage. Assuming this to be true, there are several responses to this objection. First of all, the matter of whether attenuated or no benefits should be offered to certain heterosexual unmarried cohabitants is a matter best left to the legislature. They are the ones best able to decide at what point benefits ought to be extended. In the case of marriage, the legislature has chosen to extend the presumption to all married cohabitants, regardless of the duration of their relationship or the lack of mutual interdependence. It is well known that some marriages, like some unmarried cohabitation relationships, are of short duration. Despite this, the legislature nevertheless offered the benefit to all married cohabitants. Further, the MPA has built-in devices to allow courts to rebut the presumption of equal sharing where appropriate to do so. Section 13 of the MPA lists certain factors the court may consider in delineating a smaller share of assets, including at paragraph D, quote, the length of time that the spouses have cohabitated, end quote. This provision, or its equivalent, has been applied by courts throughout the country to diminish the percentage of entitlement of one spouse on the dissolution of a short-term marriage. I do not propose to review the jurisprudence on this provision here, but commend the reader to a text and article on the subject. It is no excuse to deny the benefit of equal sharing to all heterosexual unmarried cohabitants simply because some members of the group do not seem to deserve nor want its equal division. The legislature is in the best position to craft legislation that takes into account the difficulties associated with extending the benefit. It is clear, though, based on the purpose of the MPA and the functional equivalency of the two types of relationships relative to that purpose, that extending the benefit of equal presumption solely to married cohabitants constitutes a serious attack upon the dignity of the claimant and all heterosexual unmarried cohabitants. It sends the message that, although the need for a simple means of dividing the assets on dissolution exists, only certain people are entitled to the benefit because of a status wholly unrelated to that need. In short, it demeans the dignity of an equal to treat him or her with less respect than his or her functional equals. Like the Court of Appeal, I agree that the MPA fails to recognize the contributions made by parties to a non-marital relationships, and that such recognition has the effect of demeaning them as human beings. F. Choosing to marry and choosing to cohabitate. Effect on dignity. One of the appellant's main submissions was that the deliberate non-recognition of the contribution made by heterosexual unmarried cohabitants to their relationships is done as a means of giving effect to the intentions of those entering into such relationships. In a different vein, the appellant also argues that marriage involves a considered choice to enter into a relationship that, by its very nature, is infused with certain legal rights. The same cannot be said, it is asserted, for those who enter into unmarried relationships. Based on this belief, legislation that fails to extend its benefits to heterosexual unmarried cohabitants merely gives effect to their intentions. In fact, it serves to enhance their dignity by respecting their choice not to be bound by the rigors associated with marriage. With great respect, such an argument fundamentally misconceives the reasons people enter into relationships in the first place. It is an assumption based on scant evidence at best. I will in fact show that the MPA has nothing to do with consensus and everything to do with recognizing the needs of spouses, as discussed earlier. I believe it to be highly problematic to conceive of a marriage as a type of arrangement people enter into with legal consequences of its demise taken into account. In the first place, most people are not lawyers. They are often not aware of the state of the law. Worse, many maintain positive misconceptions as to what obligations and rights exist in association with marriage and other relationships. See Law Reform Commission of Canada, Studies on Family Property Law. The Law Reform Commission in Nova Scotia accepted that there is an anecdotal evidence that unmarried partners believe that the MPA applies to them after 1 year of cohabitation. See Law Reform Commission of Nova Scotia, Final Report, Reform of the Law Dealing with Matrimonial Property in Nova Scotia. Even assuming that people contemplating marriage are, as a whole, fully aware of their legal rights and obligations as married people, it is a mistake to base the obligations imposed by the MPA on the partner's perceived consensus to be bound by these obligations through marriage. Commenting on both the choice of marriage and the choice not to marry, the Law Reform Commission in Tasmania wrote the following: "Sometimes, two people choose to live together in absolute freedom and choose not to marry, just to avoid the responsibilities of marriage. But, although this is becoming more common, it affects a small minority of de facto relationships, and we believe that the vast majority of people who live together without marrying do so without thought of the legal consequences. It is, we think, fanciful to think that any more than a handful of people organize their personal lives in this way in order to achieve specific legal consequences." End quote. Couples do not think of their relationship in contract terms. The observations of one author on this point are particularly poignant. Quote, "Now the confusion in the law arises from the fact that while marriages and domestic partnerships are quite obviously more like friendships than hamburgers, they also give rise to legally enforceable obligations, which lead some people to forget the obvious and think they are like hamburgers after all. The error apparently arises from the mistaken assumption that the legal obligation arising from marriage must have their source in a bargained for exchange. The mistake is probably facilitated by the fact that the reciprocal nature of a successful marriage gives it a superficial resemblance to a bargained for exchange, which is, after all, the source of so many legal obligations. But we must remain clear about the difference. Lunch with my friend may leave me with a sense of social debt that is real but non-specific. Friendship involves communicating interest in and concern for another's welfare over a longer time horizon. Opportunities to reciprocate may not present themselves in a convenient sequence for turn-taking. The debt to the restaurant, by contrast, involves paying $23.37 now." End quote. In other words, the fact that marriage gives rise to legal obligations does not by itself signal that the source of those obligations is some bargain for exchange or the product of a consensus. While the price of a haircut is known in advance and can be contracted for, with a higher price for perms than for brush cuts, the same cannot be said about marriage. The marital relationship changes over time. Houses and other assets are bought and sold. One of the partners is promoted or loses their job. Children are born, accidents occur, or a member of the family becomes ill. These and other events are rarely anticipated at the outset and appropriately bargained for. Further, neither spouse can anticipate who will contribute what to the marriage. As a consequence, even the most intelligent of adults lacks the capacity to evaluate the commitments involved in any agreement dealing with the consequences of a dissolution that will only come after great change occurs in the relationship. See further analysis of cognition in M.A. Eisenberg, The Limits of Cognition and the Limits of Contract, published in 1995. Recognizing the obvious limits to conceptualizing the obligations flowing from marriage as a form of consensus, the legislature in Nova Scotia first enacted its matrimonial property legislation without regard for the wishes of married cohabitants at the outset of their relationship. Section 5, Sub 1 of the MPA explicitly states that the matrimonial property regime applies to spouses who enter into marriage, quote, "before or after the first day of October, 1980, end quote. The MPA's predecessor contained similar wording. Two persons who married in the 1960s, for example, would fall within the statutory presumption of equal sharing. In the 1960s, marriage did not entail the existence of this presumption. If there was any contract or consensus regarding the legal obligations accruing on dissolution, a default presumption of this sort would not have figured into the discussion. One can withdraw from this one simple conclusion, that the MPA does not base the presumption of equal division on some preconceived consensus. If anything, Section 5 Sub 1 serves to nullify any consensus parties may have had regarding the division of assets when they married before the enactment of the MPA's predecessor. I consider it somewhat facetious for the appellant to argue that the MPA is designed to give effect to the choices made by married and heterosexual unmarried cohabitants when the legislation expressly applies to people who married at a time prior to the enactment of the MPA or its predecessor. If I am incorrect in concluding that the source of the obligations in the MPA is not based on the choice of marriage, it does not follow that heterosexual unmarried cohabitants enter into their relationship specifically to avoid those legal obligations. In other words, the choice argument fails from both sides. Many unmarried partners do not choose to cohabit or remain unmarried so as to avoid the legal consequences of marriage. The reasons why people choose to cohabit are numerous. Some people have attempted to catalog these potential reasons. An excellent list is found in Pain and Pain, Supra, at page 50. These authors list 8 potential reasons why parties choose to cohabit, reasons which I would say are not mutually exclusive. The existence of a legal impediment to marriage. The existence of some religious obstacle to marriage. The perception by one or both of the potential cohabitants that marriage constitutes a relic of patriarchy with its assumed roles of male domination and female subordination. The wish to avoid some or all of the legal rights and obligations associated with marriage. The removal of the stigma associated with unmarried cohabitation due to the weakening of religious influence. The desire to enter into a, quote, trial marriage, end quote. The wish to maintain entitlements to particular benefits that would be lost in marrying, and simple convenience. It is impossible to pin any one of these reasons on all people who choose not to marry. In her study of heterosexual, unmarried cohabitants living in Britain, C. Smart concluded that, quote, the majority of the men and women in our study did not cohabit because they were selfish and immoral, or because they rejected the ideological/patriarchal basis of marriage. Cohabitation was not necessarily a self-centered nor a progressive form of union. On the contrary, some of these cohabitating unions seem to be very similar to an ideal type of marriage with its emphasis on companionship, shared interests, commitment to children, and shared economic resources. Other cohabitating unions, however, seem to reproduce some of the worst aspects of traditional heterosexual marriage, such as domestic violence, a rigid sexual division of labor, and financial insecurity for mothers. Only about a quarter of these interviewed saw themselves as taking a stand against marriage as an institution, or saw marriage as an irrelevance in the light of a superior form of private commitment. Many of the women we interviewed actually wanted to get married, albeit to a better person that they had yet to meet. Equally, some of the men went on to marry other women with whom they formed relationships later on. We cannot therefore simply describe these trends as, quote, progressive or regressive, end quote. The choices people make have different meanings in different contexts, and we need to be constantly in tune with these complexities, rather than oversimplifying and overgeneralizing. See C. Smart, Stories of Family Life, Cohabitation, Marriage, and Social Change, published in 2000. The choices made by the cohabitants in her study were occasionally based in whole or in part on the desire to avoid the legal consequences of marriage. However, this could not be said of all heterosexual unmarried cohabitants. The moral of the story is that not all people choose to cohabit to avoid the legal consequences of marriage. Those that do often do for other reasons as well. Some commentators go even further by suggesting that personal autonomy and choices are very rarely involved in the choice to cohabit. In Marriage and Cohabitation, Has the Time Come to Bridge the Gap? In Special Lectures of the Law Society of Upper Canada, 1993, Family Law, Roles, Fairness, and Equality, W. H. Holland espouses the view in the following words, quote, in many cases, there is little planning and the parties cohabit without having given very careful thought to where the relationship is heading. In fact, it is doubtful whether many couples are aware of the differences in legal consequences of marriage and cohabitation, and that cohabitation is chosen to avoid the legal consequences of marriage. As Macklin pointed out in E.D. Macklin, Non-Marital Heterosexual Cohabitation, published in 1978, quote, living together is seldom the result of a considered decision. And in a survey of married and unmarried couples, to all or most of them, the future seemed to be something diffuse that one does not discuss or think about in detail, end quote. I agree with this interpretation. It also reflects the fact that the existence of many heterosexual, non-marital relationships are rarely the product of choice, in the sense that the choice not to marry is not a matter belonging to each individual alone. The ability to marry is inhibited whenever one of the two partners wishes to marry and the other does not. In this situation, it can hardly be said that the person who wishes to marry but must cohabit in order to obey the wishes of his or her partner chooses to cohabit. This results in a situation where one of the parties to the cohabitation relationship preserves his or her autonomy at the expense of the other. Quote, the flip side of one person's autonomy is often another's exploitation, end quote. Under these circumstances, stating that both members of the relationship chose to avoid the legal consequences of marriage is patently absurd. The argument that cohabitation is mainly the result of a considered choice was also rejected by the court in Myron, commenting on whether distinctions based on marital status are distinctions founded on immutable characteristics. Justice McLaughlin wrote the following at paragraph 153, quote, "In theory, the individual is free to choose whether to marry or not to marry. In practice, however, the reality may be otherwise. The sanction of the union by the state through civil marriage cannot always be obtained. The law, the reluctance of one's partner to marry, financial, religious, or social constraints. These factors and others commonly function to prevent partners who otherwise operate as a family unit from formally marrying. In short, marital status often lies beyond the individual's effective control." End quote. I made the same observations at paragraphs 95 to 97, concluding that, quote, "It is small consolation indeed to be told that one has been denied equal protection under the Charter by the virtue of the fact that one's partner had a choice." End quote. Nothing has changed since Myron was decided to indicate that these statements are incorrect. They apply with equal vigor to the Charter challenge in the present case. Incidentally, arguments calling for the drawing of a distinction between married cohabitants and heterosexual unmarried cohabitants based on the choices made by these two types of couples have been wholeheartedly rejected by Nova Scotia's Law Reform Commission. In support of their choice argument, the appellant placed great emphasis on the findings of the Alberta Institute of Law Research and Reform, contained in an 18-year-old survey. This survey was reviewed by the Alberta Court of Appeal in Taylor and Rossou, 1998. A decision holding that the restriction in the Domestic Relations Act on the availability of spousal support to married cohabitants violated the Charter. The survey found that the average non-marital cohabitation relationship lasts 2.08 years. The 1995 General Social Survey indicates that this average has gone up to 3 years since 1984. Although the data contained in the Alberta survey is obviously dated, it is still of historical interest to the review of their conclusions. For instance, heterosexual unmarried cohabitants rank the reason, quote, "didn't want the legal commitment of marriage," end quote, as the fourth most important reason for choosing not to marry. For the purposes of these comments, I am presuming that all the respondents had a choice, something I rejected earlier. Each respondent was asked to rank each of the possible reasons for not marrying on a scale of 1 to 5. Curiously, only half of the respondents ranked the legal commitment answer at all. This is not reflected in the survey, as the order of importance is based on the mean score, regardless of how many people even chose it as a reason. Nearly twice as many respondents ranked, quote, "love" and "companionship," end quote, as the reasons why they chose to cohabit non-maritally. The mean score for these responses was far higher than the one for the legal commitment answer. Further, there is no indication as to what is meant by the words, quote, "legal commitment," end quote. There is no way of knowing whether this constituted a specific reference to all of the legal rights associated with marriage, support, property, intestacy, and dower rights, for example, or whether it is a vague reference to the fact that marriage is formally entered into. A lot of people speak about legal commitments in vague terms. Few people think of legal commitments in the precise manner that lawyers and judges do. Overall, the findings of the survey are somewhat flawed and uncertain. They can hardly be relied upon as justifying a wholesale distinction being drawn on the basis of marriage. Even if these findings do show that unmarried cohabitants as a whole generally chose to cohabit to avoid the legal consequences of marriage, those findings would be irrelevant. The realities of the relationship at its termination are what the MPA addresses, not the intentions of the party at the outset. Based on the above comments, it is my view that the argument that the claimant's dignity was not violated by legislation enacted to respect her choice, and the choice of all heterosexual unmarried cohabitants, fails. This argument fails to account for the fact that the MPA rights are not based on choice or consensus. Moreover, it is incorrect to paint each unmarried cohabitant with the same brush as regards to the quote-unquote choice to cohabit. For many, choice is not an option. For those where choice is in fact an option, few structure their lives by marrying or not marrying to take advantage or avoid particular legal obligations. The MPA does not therefore promote the dignity of the claimant. In fact, its failure to appreciate the absence of choice many cohabitants face with its concomitant exploitative features demeans the dignity of heterosexual unmarried cohabitants. G. Current recognition of heterosexual unmarried cohabitants. Courts and legislatures in this country have taken stock of the fact that denying certain benefits to a class of persons on the basis of their marital status is unjust where the need for these benefits is felt by both unmarried and married cohabitants equally. In response, courts have extended certain benefits to heterosexual unmarried cohabitants where the legislature has refused to do so. Legislatures, too, have enacted a flurry of legislation to extend certain benefits to heterosexual unmarried cohabitants. The appreciation of an injustice and the resulting actions reinforce the view that the denial of marital property benefits demeans the dignity of heterosexual unmarried cohabitants. The steps taken constitute an acknowledgement of an historic attack upon the dignity of these individuals. By attempting to redress this unjust situation, the message is sent that there is an awareness of its existence and the need to stamp it out. On the litigation front, a challenge to legislated insurance provisions extending benefits solely to unmarried heterosexual cohabitants was successful. See Myron. In Alberta, the Court of Appeal struck out a definition of quote-unquote spouse that limited the right to spousal support to those who were legally married. See Rosu. In Wyonka Estate, 2002, the court declared unconstitutional a limited definition of quote-unquote spouse contained in Alberta's dependence relief legislation. Finally, a charter challenge to the definition of spouse found in Saskatchewan's old marital property legislation was successful in CLW and GCW 1999. On the legislative front, each province and territory now has legislation on the books defining quote-unquote spouse in a way so as to extend child and spousal support obligations to certain heterosexual unmarried cohabitants. With respect to marital property, a number of provinces and territories have extended the benefit of the presumption of equal sharing to certain heterosexual unmarried cohabitants. These include Nova Scotia, Manitoba, see the Common Law Partners Property and Related Amendments Act, not yet proclaimed, Saskatchewan, the Family Property Act, and Nunavut and the Northwest Territories, see Family Law Act 1997. Quebec enacted legislation in 2002 extending the rights and obligations of marriage to particular registered civil unions. Further, several provincial law reform commissions have called for the reform of their province's legislation. For example, the current recommendation from the Law Reform Commission in Ontario is that the definition of quote-unquote spouse in that province's marital property statute be extended to include heterosexual unmarried cohabitants. See Ontario Law Reform Commission. The enactment of the Modernization of Benefits and Obligations Act in 2000 by the federal government has also virtually eliminated any distinctions in federal legislation that existed between heterosexual married and unmarried cohabitants. It should also be noted that human rights legislation throughout Canada recognizes quote-unquote marital status as a ground of discrimination. Finally, there exists a great number of other statutes at the provincial level that include heterosexual unmarried cohabitants within a more expanded definition of quote-unquote spouse. The legislative branch has made great strides to ensure that heterosexual unmarried cohabitants are given the respect due to them in society. This recognition through the extension of benefits speaks volumes to the injustice previously caused by virtue of exclusions based on marital status. By recognizing the injustice of denying equal benefits to functional equals, legislatures confirm the injustice of maintaining similar distinctions in granting marital property rights. The deliberate choice to extend many benefits falling short of extending marital property ones exacerbates the feeling that the need of heterosexual unmarried cohabitants are being ignored. The message is that, with respect to dividing assets and ensuring the orderly dissolution of the relationship, heterosexual unmarried cohabitants do not have similar needs as their married counterparts. Such a message simply demeans the dignity of the claimant and her fellow unmarried cohabitants. H. Inadequacy of current equitable remedies. No analysis of the effects of the under-inclusive MPA on the claimant's dignity would be complete without some reference to the existing remedies available to heterosexual unmarried cohabitants. I accept that the failure to acknowledge these people in the MPA may not violate their dignity or self-worth if adequate alternatives are available. One must presume that the legislature is aware of these legal alternatives in choosing not to extend the presumption of equality under the MPA. They may be of the view that heterosexual unmarried cohabitants are already sufficiently protected by the common law and equity, rendering legislative intervention unnecessary. The The Supreme Court has made many strides since Murdoch to recognize the presence of unjust enrichment in situations involving the dissolution of non-marital relationships. The court has been of great assistance to these litigants by recognizing, for instance, that the provision of domestic chores may constitute the granting of a significant benefit under the first step of unjust enrichment. See Sorochan and Sorochan, 1986. The court has also made it easy for parties who pass the first step, conferral of benefit, to prove that there has been a corresponding deprivation. At page 45 of Sorochan, the court noted that the devotion of one's free labor typical in most relationships can easily be seen as a deprivation. On the third step, the court has also reduced the claimant's burden by linking the absence of a juristic reason for the enrichment and deprivation to the absence of any obligation on the part of the contributing spouse to perform the work and services carried out during the relationship. See Sorochan. The Peter case at page 1018 even contains the comment that the provision of services by itself creates a presumption that they were provided with the expectation of compensation. While I fully endorse and applaud this court's attempts to make the unjust enrichment doctrine more accessible to litigants, I am the first to acknowledge the limitations inherent in seeking out a remedy under this head of obligation. In the first place, the principles relating to the proper remedy to grant it are complex and uncertain. For a constructive trust to arise, the claimant must show a direct link between the property and the services rendered. This concept can lead to fairly uncertain results. For instance, it is fairly difficult to establish the quantum of one's trust entitlement. Measuring the value of household services, domestic chores, and other such intangibles is no easy task. It is also highly unpredictable. Should the claimant benefit from a trust of 10%, 25%, 50%, or more for simply doing regular domestic chores? Are farmers' cohabitants more likely to get a greater share because they perform farm chores in addition to the usual domestic services? Unfortunately, great uncertainty prevails in the answer. Counsel must find it difficult to advise their clients regarding what they can expect from an application for a remedy under unjust enrichment. The uncertainty makes negotiated settlements much more difficult to achieve. To have recourse to the courts is prohibitively costly. Overall, these are problems unmarried cohabitants have to face at a very difficult time in their lives. Married persons undergoing divorce are offered a simple alternative. The contribution of both spouses is automatically acknowledged with a 50% presumed entitlement. It is easier to do the accounting when a strong benchmark such as this is offered. It is not nearly as simple when the quantum is up in the air and left to be established by a court or by parties after long and costly negotiations. Many of these comments are reiterated by Nova Scotia's Law Reform Commission in their 1997 report advocating for an extension of the presumption to cover heterosexual unmarried cohabitants. The situation facing heterosexual unmarried cohabitants today is no different than the one facing married couples in the late 1970s. The same inadequate, costly remedies that led to reform for married couples are now the only remedies available to non-marital cohabitants. By 1980, the Supreme Court of Canada had already awarded one divorced wife a constructive trust in a significant number of her husband's assets. See Rathwell. Despite the presence of equitable remedies through unjust enrichment and trust law for separated married persons, the predecessor to the MPA was enacted. The legislature must have realized at the time that the judge-made remedies insufficiently dealt with the realities faced by divorcing couples. In stipulating a presumption of equal contribution to the marriage, the legislature avoided the difficulties of establishing contribution and the degree of that contribution. If these remedies did not adequately address the concerns of married couples, it follows that the same problems are to be found today for heterosexual unmarried cohabitants. There is a significant difference between the marital property regime and the remedies currently available under trust law and unjust enrichment doctrines. I hold that it is incorrect to say that the claimant's dignity is not demeaned by offering her remedies that are greatly deficient relative to the legislated property regime. Those remedies do not come close to affording heterosexual unmarried cohabitants equal treatment with those who are married. 4. Conclusions respecting Section 15 Sub 1 of the Charter. Heterosexual unmarried cohabitants have historically faced disadvantages through a legal system that fails to acknowledge them as legitimate family forms. This pre-existing disadvantage has abated in recent years, but remains exacerbated by the denial of equal treatment in the MPA. In failing to account for these people, the MPA does not serve a justifiable, ameliorative purpose, nor does it provide a remedy in response to the actual needs of unmarried people. Worse, this failure to provide the benefits of the MPA constitutes a failure to provide a fundamental benefit at a time when it is most needed. In doing so, the legislature draws a distinction based on a status wholly unrelated to the actual needs of people whose relationships of interdependence have come to an end and who, as a result, require redistribution of economic resources through property equalization and support. These needs exist whenever any relationship of dependency breaks apart. The need is not tied to marriage itself, but to the interdependence created through long-term relationships. In short, the MPA fails to recognize the contributions made by non-married persons to their relationships. This refusal to acknowledge their contribution sends the message that, by virtue of their marital status alone, their relationship is less worthy of respect, recognition, and value. Members of this group feel the loss of dignity by this lack of acknowledgement. Moreover, their dignity is further attacked by claims that the MPA is designed to give effect to the intentions of married and unmarried persons at the outset of their relationships. Such claims ignore the express purpose of the MPA to remedy ills associated with the termination of these relationships. The right to a presumption of equal contribution, after all, only arises when the relationship comes to an end. Initial intentions are therefore of little consequence. In fact, few people realistically believe that any significant number of human beings enter into relationships of love, affection, and companionship in order to produce a particular legal outcome. If anything, some people are unaware or positively mistaken about their legal rights as married or unmarried cohabitants. Worse still, many heterosexual unmarried cohabitants cohabit not out of choice, but out of necessity. For many, choice is denied them by virtue of the wishes of the other partner. To deny them a remedy because the other partner chose to avoid certain consequences creates a situation of exploitation. It certainly does not enhance the dignity of those who could not, quote-unquote, choose to cohabit. Recognition of the value of unmarried cohabitation by courts and by legislatures also bolsters the view that historic non-recognition was unjust. Attempts to remedy this injustice confirm the existence of the injustice is not providing a remedy. Finally, it cannot be said that the MPA survives Section 15 Sub 1 scrutiny because of the availability of alternative remedies. These remedies are inadequate relative to those accorded spouses under the MPA. They were not good enough for married people in 1980. That has not changed for their unmarried counterparts. I conclude that the purposes of Section 15 Sub 1 are not furthered by the unamended MPA. As such, the claimant has successfully shown a violation of her dignity. Given my conclusions on the first three steps, it follows that the MPA violates Section 15 Sub 1 of the Charter and is therefore prima facie unconstitutional. C. Is the legislation saved by Section 1 of the Charter? Having found a violation of Section 15 Sub 1 of the Charter, it remains to be considered whether the MPA is saved by virtue of the application of Section 1. I conclude that the Section 1 justification test fails on the first step of the analysis, pressing and substantial objective. It also fails the first aspects of the second step of the analysis, the proportionality analysis. There is no rational connection between the exclusion of heterosexual unmarried cohabitants and the legitimate purposes of the MPA. There is no need to consider the second and third aspects of the proportionality analysis. 1. General principles. The question of whether the MPA constitutes a reasonable limit that can be demonstrably justified in a free and democratic society can only be answered by reference to the principles first set out in the Queen and Oakes, 1986, and since interpreted by this court on countless occasions, the most recent in the context of a Section 15 Sub 1 challenge being M and H and Lavoie. Two broad inquiries are involved. First, the goal of the legislation is ascertained to determine if it relates to concerns, quote, which are pressing and substantial in a free and democratic society, end quote. See Oakes. It is only these objectives that are of sufficient importance to justify a breach of the Charter. The second stage amounts to a proportionality analysis which balances the interests of society with those of groups and individuals. The proportionality stage is divided into three inquiries or branches. First, is the MPA rationally connected to this objective? Secondly, does the MPA impair the right no more than is reasonably necessary to accomplish this objective? Finally, a balancing is conducted between the effect of the discrimination and the benefit achieved by it to determine if they are proportionate. A negative answer to any of these inquiries resolves the matter in favor of the claimant and against the government. The burden under Section 1 is an onerous one. It is best captured in this passage from Lavoie at paragraph 6, quote, "This brings us to Section 1 of the Charter, and the question of whether the discrimination this law affects is justified in a free and democratic society. In conducting the Section 1 analysis, it must be remembered that it is the right to substantive equality and the accompanying violation of human dignity that has been infringed when a violation of Section 15 sub 1 has been found. See Corbière. Indeed, cases will be rare where it is found reasonable in a free and democratic society to discriminate. See Adler and Ontario, 1996. Discrimination on the basis of non-citizenship will attract close scrutiny. To quote Justice Laforest in Andrews at page 201, "If we allow people to come to live in Canada, we cannot say why they should be treated differently from anyone else. Section 15 speaks of every individual. There will be exceptions, no doubt, but these require the rigorous justification provided by Section 1. End quote. The majority of this court in Andrews held that the burden of justification in cases such as this is onerous. In the present case, the onus fell on the appellant to justify the charter violation. In its attempt to discharge the onus, the appellant presented this court with no proof on the record as to the legislative intent surrounding the enactment of the MPA and its predecessor. While I would have preferred evidence on this matter, I nevertheless will deal with the appellant's attempt to discharge its onus. 2. Pressing and substantial objective. In Vrend, at paragraph 109, Justice Iacobucci states that, where a law has been found to violate the Charter due to its under-inclusion, the purpose is to be gleaned by a consideration of the legislation as a whole, the provision under scrutiny, and the omission itself. With respect to the MPA, its overall purpose can easily be gauged by reference to the preamble set out earlier in these reasons. The general purpose appears to be to strengthen the family by providing for a needed redistribution of wealth at the termination of marriage. This redistribution, according to the preamble, is facilitated by acknowledging the contribution made by both spouses to the marriage. The appellant in its factum writes at paragraph 89 that the objective of the MPA is, quote, the protection of individuals from the harmful economic effects following the breakdown of marriage, end quote. I agree with this characterization of the objective, especially in light of the explicit wording of the preamble. The analysis is not complete, however, without a review of the provision defining the word, quote-unquote, spouse. When the provision in question and the omission are added into the mix, the objective becomes a little less clear. It is argued that, considering the legislation as a whole, as well as the definition of quote-unquote spouse with its inherent omission, the MPA's purpose is the promotion of marriage through the creation of a simple regime available on its dissolution. In light of this court's decision in Myron, the objective of promoting marriage over other functionally equal forms of intimate relationships, like heterosexual unmarried cohabitation, is not permissible. It is a discriminatory objective. As Justice Dixon states in the Queen and Big M Drug Mart Limited, 1985, quote, both purpose and effect are relevant in determining constitutionality, end quote. I therefore agree with the finding of the Court of Appeal in the case at bar that the appellant is not entitled to rely on an objective that supports the institution of marriage over non-marital cohabitation relationships. Looking at the omission of heterosexual unmarried cohabitants specifically, I do not see what pressing and substantial objective such exclusion pursues. I have already dealt with the reasons put forward by the appellant for this exclusion. I found them to be unconvincing. There was no contractual or choice basis for drawing the distinction between the two groups in question. Further, there was no major difference between the two relationships relative to the consequences felt by both on dissolution. There does not, therefore, appear to be a pressing and substantial objective to the omission of heterosexual unmarried cohabitants. Taken as a whole, the appellant's characterization of the objective is incomplete. The true objective of the MPA, to use the appellant's words and my own, is, quote, the protection of married individuals from the harmful economic effects following the breakdown of marriage to the exclusion of all non-married cohabitants, end quote. As a whole, this is not a constitutional objective. As a result of the foregoing analysis, I conclude that the appellant has not met the onus under Section 1 to demonstrate that the purpose of the MPA and the provision in question is so substantial as to justify a breach of a constitutional right. 3. Proportionality. Although it is not strictly necessary for me to continue with the proportionality branch of the Oakes test, a full answer to the questions before this court would not be complete without some comments on this matter. For the purposes of the proportionality analysis, I will assume that the MPA serves one of two constitutional objectives. The first objective is the promotion of marriage, one that I have found not to be pressing and substantial, in light of the discriminatory nature of the objective. The second, broader objective is that of ensuring that parties facing the dissolution of any relationship of some interdependence are given full and fair access to an equitable means of resolving their differences through wealth redistribution in the form of marital asset equalization. This broader objective is acknowledged not to be the one pursued by the MPA, given the limitation on the definition of quote-unquote spouse. I would add to these objectives the goal of reducing the pressure on public welfare. Minimizing the burden on the welfare system has been advocated as one of the purposes of the legislation that distributes wealth through support or property division. At the rational connection stage, one begins by determining whether there is a nexus between the objective and the means chosen to further that objective. The means here include the provision and the omission, C, M, and H. In this case, the provision and omission are indistinguishable, both being contained in the definition of quote-unquote spouse with its inherent exclusion. Taking the broadest possible objective first, that of providing for an equitable means of resolving property disputes on the dissolution of all relationships of some permanence and interdependence, it is quite clear that excluding a whole group that displays the very characteristics of permanence and interdependence, as well as the same needs on dissolution, is not rationally connected to this objective. In terms of the welfare objective of the MPA, this exclusion creates potential situations of poverty for people who have grown dependent on their unmarried partner and find themselves without the means of support at the end of their relationship, nor with an easy way to access the potential wealth held by the former partner. Adopting the narrower objective of promoting marriage, I do not see how excluding non-married persons promotes the institution of marriage. If the institution of marriage is promoted by way of a presumption of equal contribution, it makes little difference if that same presumption is accorded to any other group of the people. The presumption will still be there for married persons. For them, the vaunted MPA benefits are always available no matter who else has access to them. In other words, excluding or including others within the scope of the MPA is not a means that can be said to be rationally connected to the objective of promoting marriage. Like Justice Iacobucci, who, in M and H, concluded that the exclusion of same-sex couples from the spousal support regime of Ontario's Family Law Act does not further the objective of assisting heterosexual women, I conclude that the exclusion of heterosexual unmarried cohabitants does not assist married cohabitants. The rational connection test fails. 4. Conclusion respecting Section 1. The appellant has failed to discharge its onus under Section 1. None of the objectives considered are pressing and substantial. Assuming that they are, the means chosen are not proportional to the objectives due to the absence of any connection between the exclusion of unmarried heterosexual cohabitants from the MPA and the purported purpose of the statute. There is no need to enter into any of the other steps under the proportionality analysis. Conclusion. The definition of spouse contained in Section 2 sub G of the Matrimonial Property Act violates Section 15 sub 1 of the Charter in a manner that is not saved by Section 1. Since the MPA has been amended and since the parties have settled their dispute as regards the division of property and assets, I do not need to discuss the issue of remedy. Accordingly, this appeal is dismissed with costs throughout. I would answer the constitutional questions as follows. 1. Does Section 2G of the Matrimonial Property Act of Nova Scotia discriminate against heterosexual unmarried cohabitants, contrary to Section 15 sub 1 of the Charter? Answer. Yes. 2. If the answer to question 1 is yes, is the discrimination a reasonable limit prescribed by law which can be demonstrably justified in a free and democratic society under Section 1 of the Charter? Answer: no.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.